Hi friends, welcome back to PERIDOT TV. How are you doing? How is your weekend going? Human rights lawyer GT Ogunye has condemned reports that the Nigerian government was making moves to punish Justice Taiwo of the Federal High Court, Abuja, for granting pro-democracy campaigner and publisher of Sahara Reporters, Omoyele Sowore, bail in a case involving him and the Department of State Services. Expressing his views in a post on Facebook, Ogunye described the news as a deliberate attempt to intimidate the judiciary into doing the bidding of the government, which runs foul to the rule of law. I'll quickly show you what he wrote on his official Facebook handle. And before that, may I ask you to kindly tap on that subscription button if you have not done so, and also the red notification icon bell. Tap on it so you will be notified whenever new videos are uploaded. Here is the official Facebook handle of GT Ogunye. Here he writes, in response to the federal government, as you know, this present administration has become a tyrant. They've become a dictator. This is the dark days and dark ages of military rule in Nigeria. Federal government to drag judge before the NJC for granting Sowore's bail. He writes, our attention has been drawn to the story published today in the nation's newspaper under the above caption. The story, quoting undisclosed sources, states that the federal government of Nigeria is determined not to only to appeal the decision of the Federal High Court, Abuja Judicial Division, Quorum Justice Taiwo, granting bail to Mr. Omoyele Sowore, the detained proclaimer of the Revolution Now movement, but has also decided to file a petition of judicial misconduct against the judge for granting bail to Omoyele Sowore, allegedly in excess of his jurisdiction. According to the report, bail could not be granted to a person who is facing a charge of treasonable felony. We are compelled, he said, to react to this story for a number of reasons. We believe that the story is being laundered through the nation's newspaper to deliberately misinform and mislead the reading public and the Nigerian people on this issue. We believe the story is also calculated to justify the unwarranted and irresponsible disobedience of the court order granting Omoyele Sowore's bail pending the time he may be arraigned in court in respect of the charge, information said to have been filed against him. We are of the opinion that the story is meant to prejudice the enforcement of Omoyele Sowore's right to liberty whenever he may be arraigned in court on the said charge information, and frustrate the prospect of his being granted a post-charge and arraignment bail. The story is preemptive and published to scare the trial judge that may preside over his charge, arraignment and trial, to refuse to exercise his discretionary power to grant him bail whenever he is eventually arraigned. And we believe the story is meant to intimidate, harass, and embarrass Honorable Justice Taiwo, who acted appropriately, judicially, and even judiciously in granting Omoyele Sowore's bail. Upon the expiration of the 45 days, he had previously granted the SSS to detain and investigate Omoyele Sowore regarding the criminal allegations made against him. By the story, very sadly, the Nation newspaper has lent its journalistic weight to the waging of a psychological warfare on a judge for doing nothing other than performing his judicial functions and exercising his judicial powers under the Constitution of the Federal Republic of Nigeria, 1999, as amended. Contrary to the misinformation in the story that any person who is charged with the offense of treasonable felony in Nigeria is precluded from being granted bail, we make bold to say that all criminal offenses, including capital offenses, are bailable under section 161 subsection 1 and 2 of ACJA 2015. A suspect arrested or charged with an offense punishable with death shall only be admitted to bail by a judge of the High Court under exceptional circumstances, including ill health of the applicant for bail and any other circumstances that a judge may, in the particular facts of the case, consider exceptional. Under section 162 of the Act, a defendant charged with an offense punishable with imprisonment for a term exceeding 3 years shall, on application to the court, be released on bail except in any of the circumstances listed under the section. It is instructive to note that under section 32 subsection 1, 2 and 3 of ACJA, where a suspect taken into custody in respect of non-capital offenses is not released on bail after 24 hours. A court having jurisdiction with respect to the offense may be notified orally or in writing by an application on behalf of the suspect, and the court shall order for the production of the suspect inquiries into the circumstances of detention and admit the suspect detained to bail as the court may deem fit. From the foregoing exposition of the law, it is crystal clear that, contrary to the mischievous kernel of the story, all criminal offenses that may be preferred against any persons in Nigeria, including capital offenses, are bailable. Now, I hope you guys heard this. All offenses, including capital offenses, non-capital offenses in Nigeria, they are all bailable. For the avoidance of any doubt, Omoyele Sowore is not charged, among other offenses, with treason, a capital or death penalty punishment offense, but a treasonable felony. Now, that's what the lawyer is breaking down now. Treason is on one part, treasonable felony is on another part, and he explained what it is. A capital offense, a capital or death penalty punishment offense, that is treason, while treasonable felony, a life imprisonment offense, as a maximum punishment. He is therefore eminently entitled to be granted bail pending charge and arraignment, or pending trial upon arraignment. It is therefore wrong and unacceptable to excoriate Honorable Justice Taiwo for doing justice in the Sowore's case according to the dictates of the law. The import of the bail that was granted to Omoyele Sowore was that the judge, who earlier had granted a request of the SSS to detain him for 45 days, was satisfied that there was no other valid grounds to sustain his detention. The detention order having lapsed, the application for the extension of the period of detention having been withdrawn by the SSS following the filing of a charge information against Omoyele Sowore, the Honorable Judge concluded that Omoyele Sowore was entitled to his liberty pending the time he may be arraigned in court in respect of the offenses charged in the information, as his detention ought not to continue in anticipation of his arraignment. The judge refused to sustain the further detain him now. We will arraign him later. Illogic of the SSS. The honorable judge cannot, in our humble view, be faulted by inspiring the publication of the story and by actually publishing, saying the SSS and the nation's newspaper have committed acts of criminal contempt against the judge and the court. What has been done is unarguably an interference in the administration of justice. The publication is proposed to cow the judge and intimidate him. It is subversive of the independence of the judiciary and its majesty in administering justice. We concede that the FG may lodge an appeal against the decision of the court granting Omoyele Showore's bail. It may lodge a petition against the judge if it so wishes, and if there are justifiable and reasonable grounds to do so. But if it cannot unlawfully and rightly resort to a newspaper or media publication to scandalize the court, misrepresent court proceedings and decisions, or impugn the character or judicial reputation of the judge, twisting the law and fact of this matter. As for the Nation newspaper, it is important that it be reminded of the duty that is imposed on the mass media by the provision of section 22 of the Constitution. The press, radio, television, and other agencies of the mass media shall at all times be free to uphold the fundamental objectives contained in this chapter, and all the responsibility and accountability of the government to the people. When a newspaper that ought to take on the federal government for flagrantly disobeying the order of the court granting Omoyele Showore's bail is now peddling lies and falsehood to justify the disobedience of the order, it is no longer in doubt that the newspaper is betraying its obligation imposed by the Constitution. This is GT Ogun, Lagos, September 2019, and this is what he wrote about this federal government attitude towards the judicial system and this judge. Let us know in the comment section below what's your take about all of this. And while you're there, may I remind you, if you have not done so, to kindly tap on that subscription button and also the red notification icon bell so you'll be notified whenever new videos are uploaded. Thanks for stopping by.